Good afternoon, everyone. I'm Kurt Levy, President of the Committee for Justice. I want to welcome you to latest in our series of Zoom panels. This one is titled Supreme Court Packing and Reforms, Proposals and Prospects. With the Democrats still angry about Merrick Garland not being confirmed and about Amy Coney Barrett being confirmed right before this last election, and with Democrats now controlling both houses in the presidency, court packing and other proposals for Supreme Court and even lower court reform have become a very, very real possibility that are being, hotly debated, probably like no time since FDR's court packing plan almost a century ago. Actually, it was 84 years ago. This past Friday was the 84th anniversary of FDR announcing his court packing plan on February 5th, 1937. And I think the important thing to remember is that although these plans and proposals are motivated by recent appointments to the court, if enacted, they could last for centuries even. They would have profound legal and political consequences long after the current justices and the current configuration of the court is gone. So our panel of experts on the Supreme Court, Tom Jipping, Ilya Somin, and Joshua Braver will discuss the various proposals and their potential consequences, as well as the history of changes in the number of justices. After that, I'll ask them some questions, and then if time permits, we'll take audience questions that come through the Zoom Q&A function or were emailed to me. We've got more than a usual number of questions emailed. I guess there's a lot of interest in this topic. Without further ado, let me introduce the speakers in the order that they'll speak. Joshua Braver is an assistant professor at the University of Wisconsin Law School. His primary interests lie at the intersection of constitutional law and political theory. Similarly, he has both a law degree and a PhD in political science, both from Yale. His most recent scholarly article is really the first comprehensive conceptual overview of all 7 times in past history that the Supreme Court's size changed. Next, we'll hear from Ilya Somin. He's professor of law at George Mason University. His research focuses on constitutional law, property law, democratic theory, federalism, and migration rights. Speaking of migration rights, his most recent book, published just last year, is Free to Move, Foot Voting, Migration, and Political Freedom. And Ilya has published many articles in popular press outlets such as the Wall Street Journal, Washington Post, LA Times, The Atlantic, USA Today. And then last but not least, we'll hear from Tom Jipping, who's Deputy Director of the Heritage Foundation's Meese Center for Legal and Judicial Studies. He joined Heritage a couple of years ago after 15 years on the staff of Senator Orrin Hatch of Utah, including several of those years when he was Hatch's chief counsel on the Judiciary Committee. Tom has a national reputation really as an expert on the federal judiciary, particularly the appointment of federal judges. In fact, The Nation magazine has dubbed him the right's ablest analyst of judicial confirmation fights. And I've known Tom for a long time, so I know that that's very true. Let me ask Professor Braver to start it off.
Sure. Thank you so much for having me. I was asked to speak about the history of the court's size in relationship to court packing, and court packing would be nearly, though not completely, novel in American history. With perhaps one exception, Congress has never passed and the president has never signed a bill to pack the court. So court packing, as many of you know, is the manipulation of the court's size in order to change its ideological composition, its rulings. Its distinct danger is that it unleashes a tit-for-tat downward spiral of packing. I pack, you pack, I pack, you pack, ballooning the court's size so large that its legitimacy pops. Previous changes to the court size were based on a different and safer logic. So 3 consecutive increases to the Supreme Court size were tied to and regulated by the practice of circuit riding. For every addition of a new circuit court, you needed a new Supreme Court justice. Why was this? Well, for much of American history, there wasn't a separate tier of circuit court judges, no circuit court judges, but there were circuit courts. Each circuit court was composed of one district court judge and one Supreme Court judge. A Supreme Court judge was assigned to one circuit in which he rode. So in the 1800s, America's expanding westward at a rapid rate. These new states need new circuit courts to process their claims, but the Supreme Court justices were already literally dying from the exhaustion of riding circuit. There were just not enough justices to go around. So for years, these states would languish without circuit courts, creating real problems with the administration of justice. Hence, because of this correspondence between circuits and Supreme Court justices, for every new circuit for these new states, there would have to be one new justice. So this is not particularly the most advanced presentation, but you can see here how this works. Right up here in 1807, we go from 6 to 7 circuits, and that's to accommodate the new states of Kentucky, Tennessee, and Ohio. We add the 7th Circuit, and you get a 7th Supreme Court seat. This is a bipartisan measure. Indeed, Thomas Jefferson is the president. It's Jeffersonians who stand to benefit from this expansion, and yet 6 of the 7 dissenting votes are members of Jefferson's own party. 1837, we go from 7 to 9 circuits and also to 9 Supreme Court seats because of the addition of several new states. And in 1863, from 9 to 10 because of the addition of California, Oregon, and others. And I can speak in more detail over questions if people are really curious about how I can show this was not purely political, how there was a great deal of incentive to add many more seats and push for doing so, and they did not do it. It's not that partisanship never entered into these calculations. Everyone knew that adding a circuit gave the president an additional appointment. But despite these partisan machinations, the game had implicit rules and limits. No one thought you could increase Supreme Court seats solely because you disagreed with its decisions, nor did the parties consider retaliating against the other party's increase. The dangers we associate with court packing were mitigated and channeled by the performance and administrative motivations of these expansions. Okay, but let's get to the good stuff, the political changes. Unlike circuit riding, these changes are not about efficiency or administration. What's at stake is the court's rulings, its ideological composition. So what we have is a reduction in 1801 and a restoration of the court size in 1802. And this is no precedent. It was a failure. John Adams and the Federalists failed to deny the incoming president, Thomas Jefferson, his chance to fill the next vacancy on the Supreme Court. So in 1800, Jefferson and his party win the presidency and majorities in both houses of Congress. The Federalists are convinced the Jeffersonians are enemies of the Constitution, so they, as Jefferson bemoaned, the Federalists retire into the judiciary as a stronghold. During the lame duck, the Federalists reduced the size of the Supreme Court from 6 to 5 seats. When the next vacancy came, Jefferson would be unable to fill it. The Federalists were blocking Jefferson's next Supreme Court appointment. When the Jeffersonians come to power, Congress debates what to do. Furious House Speaker Nathaniel McCone expressed his wish to, quote, add 2 or more 3 judges to the Supreme Court. McCone wants to strike back by packing the court. The Federalist condemnation was fast and furious. No Jeffersonian rose to defend McCone against the Federalist onslaught. In fact, what's more surprising is that Jeffersonian congressmen repeatedly condemned their allies' idea, with one echoing the warning of others, quote, by increasing the number of judges at every change of administration, the number of your judges are probably to be doubled. But actions speak louder than words. And what the Jeffersonians did is they restored the court's size. So if you look again, right, we have this reduction from 6 to 5 Supreme Court seats under the Federalists in 1801. And then in 1802, the Jeffersonians restore the court size back to 6. And they described it and justified it as a restoration to the old status quo. Jefferson wrote that the repeals sought to restore our judiciary to what it was while justice and not the Federalists were its object. Adams' packing attempt is not a precedent because it was repealed and it was repudiated. Where Adams was thwarted, the Reconstruction Republicans succeeded. If there is any precedent for court packing, it's this 1866-1869 example. But if it's court packing, then it's of a slightly less risky sort. In 1866, so Andrew Johnson, the Republicans, they're fighting fiercely over the meaning of Reconstruction. 1866, Johnson announces his nominee to the Supreme Court, and Congress passes a law reducing the Supreme Court size. Congress is declaring to Johnson, I will not consider any of your nominees. But the story doesn't end there. After the Republicans wrested back the presidency in 1869, the Republican Congress restored the court's size and appointed one of their own to the new seat. In other words, Congress transferred an appointment from Johnson to the next Republican president. Nonetheless, this battle didn't degenerate into repeated rounds of packing. Why not? Here, the anti-packing norm was irrelevant because Johnson was a president without a party. Constitutional norms regulate the contestation between the two political parties. They prevent these two teams from falling into cycles of escalation. Let's take an example. What if there was a bipartisan decision to pack the court? In that case, both parties are on board, so I'm not worried about retaliation. I'm also not worried when the attack targets a president who has been deserted by both political parties. Johnson had switched parties so many times, he had alienated so many core constituencies that he had lost the faith of both the Democratic and the Republican Party. As one journalist commented, Mr. Johnson stands absolutely alone. He is his own sole remaining friend. Unhappily, he does not suffice. These attacks on political outsiders are less likely to lead to escalation between insiders. So just in this last 30 seconds, I'll talk about alternatives to court packing. There's more than one way to fight the Supreme Court. Instead of packing, the elected branches have narrowly interpreted court decisions, circumvented them through other statutes, stripped jurisdiction, and even just the threat of packing has been effective. Unlike packing, all of these measures are reversible, perhaps lessening the dangers of a downward spiral. Furthermore, while packing infiltrates and transforms the court, these measures attack the court from the outside, checking the court, causing it to retreat. It curbs rather than colonizes the court. That means these alternatives may be more likely than packing to leave the court's legitimacy bruised, but not broken. These forms of court curbing, not court packing, are the hallowed American tradition. I'll leave it there.
Thank you very much, Professor. Ilya,
Thank you.
please tell us about the various proposals that are out there.
Sure. So thank you very much to Committee for Justice for sponsoring this event, and all of you for listening, and to Josh for his excellent overview just now of the history of court packing efforts. I'm going to briefly talk about how we got to the point where we are, then talk about the court packing issue and why I think court packing is uniquely bad and arguably, at least in my view, worse than other kinds of skullduggery that have taken place with judicial nominations. And then finally, I'll talk about some other reforms that have been proposed, particularly term limits for Supreme Court justices, which I think that might be a much better way to go than going with court packing. So why are we in the situation where we are now? I think the most fundamental reason is the polarization of American politics generally, which has also resulted in polarization about Supreme Court nominations and even about lower court nominations as well. As the parties have become further and further apart on many important issues, the expected rulings of a Republican nominee have diverged more from the expected rulings of a Democratic one, which leads both parties to be more and more determined to get in their own judges and to block those of the other party. And what we've seen over the last 20, 30 years is a gradual escalation from both sides of various tactics intended to achieve that end. I don't have time to go through it all, but they include such things as filibustering nominees much more often than in the past, blocking nominees completely, and most recently, I think the GOP's hypocrisy, where in 2016, they said, if there's a nomination during a presidential election, then you have to wait until after the election to consider a nominee. But in 2020, when the vacancy arose actually much closer to the election, they said, haha, we were just kidding. Actually, we can consider a nominee right before an election. All of this, like previous Democratic maneuvering, was legal, but it did undermine pre-existing norms. And this has gotten us to the point where the idea of court packing has also been revived by many Democrats after seeing also a little bit of a revival even among Republicans in 2017, with some of them advocating the packing of the lower court. So they didn't ultimately attempt to do it. So you could say court packing is also legal, at least in the sense that the Constitution doesn't bar it. It doesn't set a particular number of Supreme Court justices. So if anything that is not specifically forbidden by the law or by the Constitution goes, you could say court packing is just another move in this game. And in a certain sense, that may be true, but I think it would be a much worse move than any of the ones that we've seen so far. The reason why is that if you can pack the court anytime you have a majority in both houses of Congress and also have the White House, that means you can completely subordinate the judiciary to your agenda anytime that occurs, and essentially block judicial review as an effective check on the power of the party and of the party that controls both houses of Congress and the presidency. And destroying the institution of judicial review, I think, is qualitatively different than simply engaging in skullduggery about blocking particular nominees or filling nominations that seats that open up in the natural course of events. And indeed, this isn't just a theoretical danger. Court packing is how judicial review and sometimes liberal democracy generally was undermined in a number of other countries abroad. Venezuela, Hungary, and some others are examples. Incipient authoritarians have court packing as one of their tools that they routinely use. So there have been some efforts to say, well, maybe if we don't call it court packing, maybe if we make it something else, like terms such as court balancing or judicial rotation, that somehow we can avoid making it look like court packing, or somehow it will be different from real court packing. I can go through the details of those proposals in questions if people are interested in them. But bottom line is, I don't think these types of circumventions will actually work, both because the opposing party is likely to see through the smokescreen, and because it's a substantive matter, it ultimately isn't all that different. And I would add, most of what I have said applies not just to packing the Supreme Court, but also packing the lower courts, which some Republicans unwisely proposed in 2017 when they had the chance, and some Democrats are potentially talking about now. So if court packing is a bad idea, are there other reforms that might be better? There's a whole bunch of other reforms that actually have been proposed that may be discussed by President Biden's incipient Judicial Reform Commission, the membership of which should be announced in the near future. One of them, which I think a wide range of legal scholars support, is 18-year term limits for Supreme Court justices. These kind of term limits won't solve all of our conflicts over the Supreme Court, but they do have some virtues. One is it regularizes the process of judicial appointments. There would be a vacancy on the Supreme Court every 2 years, and it would eliminate these vagaries where vacancies depend on chance, like whether a particular justice gets sick and passes away or retires. It also eliminates the incentive to appoint younger and younger justices so they serve for more years. And similarly, in the future, I hope after the pandemic ends, life expectancy will continue to increase, which will be a good thing, but it could easily then lead to a situation where a justice can sit for 40, 50, or even 60 years. And I think that's not something that we want, for somebody to have that much power for that long. So 18-year term limits, I think, would be a desirable reform, albeit it would require a constitutional amendment. Other reforms that have been proposed include a code of ethics for Supreme Court justices, which I don't have a strong opinion about. There might be some attempts to limit the jurisdiction of the courts, which I'm mostly not supportive of, but it depends to some extent on the details. And one reform that has a degree of bipartisan support has actually already been undertaken by the new Biden administration, where the president has reversed the policy of previous Democratic presidents of giving the American Bar Association a privileged role in screening new judicial nominations. This is something which has been done in the last 2 Republican administrations as well. So on this particular small issue, Biden has carried out his promise of achieving unity, because it turns out at this point, neither the left nor the right, especially like the ABA's previous special role in the process, albeit they dislike it for different reasons. The Biden commission that looks to be about to start seems unlikely to recommend court packing, because the person putting it together, Bob Bauer, is a critic of court packing. Moreover, court packing is unlikely to pass anytime in the next 2 years, because several key Democratic senators have said they are against it. But I do not believe the issue will just go away. It's now part of mainstream politics. It's part of the discussion. So it might take some time, if ever, to put the genie back in the bottle. And meanwhile, also, I think there will be a discussion about other kinds of judicial reform proposals, and I look forward to discussing them in more detail during the questions. Thank you.
Thank you, Ilya. And last but not least, Tom.
Thanks, Kurt, and thanks to the Committee for Justice for putting this event on. An op-ed back in the 1980s in the Washington Post looked at the uses of presidential commissions, and it said that they're usually created to study either unsolvable problems, issues that the White House wants to go away, or a crisis that genuinely need a solution. The Biden Court Reform Commission that's now being formed is none of those. That commission is simply a cloaking device for what the Biden administration, I think, and their left-wing allies already intend to do. During the presidential campaign last year, Biden said the American people don't deserve to know his position on reforms like court packing. And instead, in an October 60 Minutes interview, he said he would form a commission to look at court reform ideas, because he said the courts are out of whack. Now, he didn't define judicial wackiness in that interview, but the objective of these reforms, that certainly the ones that are coming from the left and that they hope will resonate with the administration, the objective is obvious. The only issue that these reform advocates have ever identified is that they don't like some of the decisions from the Supreme Court. Everyone knows that the objective of these court reforms is to change the ideological composition of the court so that the decisions of the court change on particular issues or in particular areas. People may remember back in 2019, Senator Sheldon Whitehouse and a few colleagues filed a brief in a Supreme Court Second Amendment case, and the last line of the brief was, and I'm quoting, "The Supreme Court is not well. Perhaps the court can heal itself before the public demands it be restructured in order to reduce the influence of politics," unquote. Well, that's code, but it's because essentially he's defining decisions he doesn't like as being influenced by politics. And the courts are well, or the court is well, when it's issuing decisions that are favorable to certain political interests. Last year, the majority leader, Charles Schumer, he spoke in front of the Supreme Court. They were hearing an abortion case, and he spoke specifically to Justices Neil Gorsuch and Brett Kavanaugh. He said that they would, quote, "pay the price if they don't stop rendering awful decisions," unquote. Now, again, decisions that the left doesn't like are defined as awful. So that, that word doesn't really tell us anything more than that. And I think what this commission is about to do is to tell us what the price is that has to be paid. So I think, it's kind of like a version of the beatings will continue until morale improves. It's at least at this point, it's kind of from the outside, these sort of warning shots. But then when you come to actual proposals, and has been said already, some may be done by legislation, others by constitutional amendment. And by the way, if they do attempt by legislation, and I know this isn't the subject of this webinar, but in order to get any kind of reform legislation through the Senate, because it's a 50-50 Senate, they would have to abolish the legislative filibuster, which, would not only permanently change the judiciary in the sense of the proposals that would be then enacted, but it would permanently change the Senate as well. Whatever the proposals are, court packing, rotating judges, requiring a supermajority to strike down, laws, or whatever else demand justice is demanding. I think the purpose is the same. They intend to destroy the independence of the judiciary so that the judiciary serves the needs of the political branches. We've already alluded to FDR's court packing push in 1937. He was reelected in a landslide in 1936 and had massive Democratic majorities in Congress. There were 80 Democrats in the Senate. He could have had passage of his legislation on the numbers, going away and coming back, right? There was no issue of a filibuster that was going to happen or anything like that. Yet his proposal was controversial for the reason it should be considered controversial today. And he even used the word reform. The bill that was introduced, S 1392, was called the Judicial Procedures Reform Act. So they even tried to kind of spin it in terms of reform. But that bill, and this is similar to what's being discussed today, we focus a lot on what its impact on the Supreme Court would be, but that bill applied to the entire judiciary. On any federal court, judges who reached the age of 70 and who had at least 10 years of service, if they didn't step aside, Congress would create additional judgeships. We're kind of dealing with that issue today at the level of, kind of on a surface level with a lot of kind of sniping back and forth and this kind of thing. The Senate Judiciary Committee in 1937 held a hearing that lasted for 28 days. The committee actually met for 28 full days over March and April. And during that time, a lot of law school deans, you certainly wouldn't hear this today, but a lot of Syracuse University College of Law dean, for example, testified, and he said that the court packing plan would create what he called a synthetic majority of the Supreme Court. Expected to be sensitive not to its oath of office, but sensitive to the will of the executive or the legislature. That was the objective then. That's the objective now. And of course, the Judiciary Committee recommended that the bill be rejected, and it was, in a sense, it was against their political interests, because the legislation that was frustrating everybody that the court was striking down was Democratic legislation. But the committee report said that it ought to be rejected because court packing tends to expand political control over the judicial department by adding to the powers of the legislative and executive departments over the judiciary. And that's exactly the argument that has to be made today. It's interesting that one of the strongest opponents, probably the strongest opponent of FDR's plan, was the American Bar Association. They not only testified, but they had actually expended what today would be close to $700,000 to survey their members and non-member lawyers all over the country. And there's a very detailed report on this in the hearing record. Large majorities of lawyers in every single state opposed that plan. And the ABA said that lawyers had not been this exercised over an issue since the Civil War. And it's interesting, commissions are interesting things, because 60 years later, the ABA itself created a commission on the independence of the judiciary. And at that time, they said the threats to the judicial independence, included criticism of judges and, shrill statements and remarks. It's like that's what the ABA thought was so seriously threatening judicial independence that they had to literally create a commission. I testified before the commission in October of 1996. But what's happening today, of course, is light years beyond that. And unfortunately, at least unless I've missed it, I haven't heard anything from the ABA about it. I think the choice today is the same as it was in 1937, and we ought to work to frame it the same way. The details, there are some pros and cons of a few of the ideas that are interesting, but the bottom line is it's the same choice that was presented in 1937. Either the independence of the judiciary from the political branches is important, is the priority, or the dependence of the judicial branch on the political branches is the priority. I'll just wind up with the way that the Senate Judiciary Committee report on FDR's court packing bill did. It said, quote, that would subjugate the courts to the will of Congress and the president and thereby destroy the independence of the judiciary, the only certain shield of individual rights. It is a measure which should be so emphatically rejected that its parallel will never again be presented. Bravo, so thanks.
Now, Tom, you're talking about the court losing its independence, and I think everyone, all three of the panelists, agreed that the court might very well lose its legitimacy if we got into tit for tat court packing. Please, all of you, please discuss how that might play out, because of course, on paper, the court would still have the same amount of power, whether it had 9 justices or 37 justices. So sketch out for me, if you could, how this would play out and what the court would ultimately become if we do get into a tit for tat.
Well, I think the issue isn't so much the power of the court as it is the power of the political branches over the court. That's why that last statement that I read from the Judiciary Committee about FDR's plan, that's what it was all focused on. And again, it's not like, I think as Ilya had said, it's not that the Constitution doesn't permit Congress to affect the structure of the courts or something, and that it's not whether they may do it, it's whether they should. And it's not like we don't have any guidance about that. On the list of grievances in the Declaration of Independence are a couple of items having to do with the politicians manipulating the courts. I mean, this isn't just a 21st century problem. So I think it's a matter of and I'll just add, the hearings made clear too, and I think Josh's scholarship has pointed this out. While there have been changes in the number of justices, Congress hasn't actually changed that number for the purpose of changing its ideology and the decisions that it renders. That's what this is about, and that's what would destroy the independence. So I think defining independence correctly and seeing what would genuinely destroy it. So it's that relationship between those branches that I think would be unalterably changed.
Joshua or Ilya, do you have any thoughts on what the role of the Supreme Court might be, 10 or 15 years from now, if we do get into a tit for tat, what that would look like?
Yeah, I think one of two things will happen. One possibility is that if the Democrats succeed in packing the court, the Republicans will just respond with similar measures of their own whenever they get the chance to do so. And unless you believe there's been a massive realignment where one party will just dominate Congress and the presidency for many years on end, the Republicans are likely to get a chance to do that. And so you could have a tit for tat resulting in a situation where whoever is in power, they will be able to, in effect, bend the court to their will, and at the very least prevent the court from striking down any laws or regulations that they especially want to see preserved. Another possibility is that the court, seeing that this spiral is going to happen, they will sort of exercise preemptive self-control and say, we're just not going to do anything to in any significant way anger the party in power. So then there might not be a further round of court packing, and the court might look independent in some sense, but it won't actually be. And I think if you look at what happened in some of these other countries where court packing occurred, I think you do see this is exactly what happens. Judicial independence does get destroyed. This may be welcomed by some people on both right and left who think, well, the real problem with the judiciary is they strike down too many laws and regulations. So if we intimidate the judiciary into submission, then the world will be a better place in the sense of it being more democratic, not necessarily big D democratic, but small d democratic. But those of us who favor strong judicial review, particularly people like me, think that the bigger problem with the courts is that they don't strike down enough laws and regulations, then that would be very problematic. And if you believe that one or both parties have trends to incipient authoritarianism, and I was one of those who said, and I still think that Donald Trump certainly had those, and there are other elements in the two parties which have aspects of that, then a strong judiciary, even one where we don't always agree with its rulings, as I certainly don't always agree with the rulings of the relatively conservative Supreme Court, that's still better than having a completely neutered judiciary, which is not much more than a lapdog of whichever party controls the White House and the two houses of Congress. Even though I do recognize preserving that does mean we have to live with some decisions we don't like, which I certainly do. There are several decisions the current Supreme Court majority has made in the last several years that I'm no fan of.
Yeah, I'll just add one other danger, which is the danger of disobedience. You know, the court, the cliche is, lacks the power of either the purse or the sword, and the court's rulings are obeyed because it's generally one of the more popular branches. And so we know from, you know, Brown v. Board to all the way Marbury v. Madison or Kim Davis, you know, the danger is not one Kim Davis, but hundreds of Kim Davises, thousands of Kim Davises. And so that's another danger. I mean, I do just want to respond to a couple things that the other panelists said, if that's okay, briefly.
Sure.
I'm a progressive, so I think I come from this from a slightly different angle. And, you know, one of them is that Ilya said that it would be an escalation for court packing to happen. And I agree, but, and that it would be worse than what was before, but that's the definition of escalation, right? We've been in escalation for a while. Each move has been worse than it was before. And so I take it that you think this move is much, much worse than what's happened before, that it's much, much more dangerous. But if you're a progressive and you agree with Ilya, right? Ilya has said these are basically stolen seats, right? That what was done was violating the norms that Republicans should have been following. Then 18-year terms is not much of a solution to remedy this problem. And it doesn't seem like it's fair for progressives then, or much of a consolation to progressives to say, yes, there's been a lot of escalation, but we are expecting you to stop at this point, right?
So
and the interesting question to me is what escalation might be possible that might be short of like a nuclear option or something like that.
I wonder, is that okay if I comment? Or so
Yes, please.
You correctly characterized me as saying that this is escalation and that the Republicans violated pre-existing norms, or at the very least contradicted norms that they themselves said in 2016 should hold. I did not say that the seats were stolen, in that a stolen seat, to my mind at least, is one that actually was illegally taken in some way. Here, it's more like improperly acquired, or whatever term you want to use, that's not stolen. What can progressives do? I think I would say two things on that. One is there are many other ways that they can make life painful for the Republican Party that wouldn't do damage to political institutions in the same way. I'm not a political strategist, but there's a lot one party can do to the other that would make them suffer in various ways that would be less destructive than this would be. But the other thing I would have to say is that, you know, we have to, if we want to preserve judicial independence, that means we have to live with some decisions that we really don't like. And I would add that if your solution, not yours personally, but that of other progressives, is to essentially go down a path which predictably leads to the destruction of judicial review, that means wiping out a whole bunch of aspects of judicial review that currently still exist and are likely to exist that progressives actually like. abortion rights, various kinds of free speech rights, protections for criminal defendants. I can make a longer list, but although the current system with the current Supreme Court majority is ones that in some cases, for understandable reasons, progressives don't like, they should ask themselves, would they like it better if judicial review was simply wiped out or largely neutered? There are some progressives who say the answer to that question is yes. And if the answer to that question is yes, then we have a much broader debate than one about court packing. Simply, if the answer to that question is no, then that means probably you have to look elsewhere for a way to retaliate or to make Republican politicians' lives more painful. And there are many possible options for that.
And the only thing I would add would be we can talk about what the norms have been and which steps that have been taken in recent years were inconsistent with those norms. In my view, it is not a comparable response to a perceived change of norms to literally amend the Constitution, pass legislation in the way it would have to be passed that would fundamentally actually legally change the very structure of one of the three coordinate branches of government. That is not a comparable response to what is perceived as a shift in norms. So I think that's a very important, because that's what we're talking about here. This isn't a kind of a shift in strategy or a modification of an approach or something like that. That happens all the time. We're talking about literally changing the very configuration and structure of one of the three branches of government.
Both Josh and Ilya talked about stolen seats. Can one of you explain to me why a lot of people talk about 2 seats being stolen? Because it seems to me if you were going to be, arguably consistent, you would say that Garland should have been confirmed and Barrett should have been confirmed, or neither of them should have been confirmed, which would make a 1-seat difference. So how do we come up with 2 seats? Josh or Ilya?
I'll let Josh go, but if he doesn't want to go, I'm happy to.
I mean, yeah, I suppose the idea would be, so yeah, I think you have a valid point, I suppose, in the sense that, Amy Coney Barrett should have been able to be confirmed, but not the other justice, according to that logic. And so it's only a 1 stolen seat. I think the thing that makes it, of course, so galling is for progressives is the transparent hypocrisy that's involved.
Yeah. So as I said before, I don't think there's really such a thing as a stolen Supreme Court seat, because I don't think there's such a thing as ownership of the seat, so to speak, until the person actually gets confirmed. But I think from the standpoint of at least some progressives, the logic of 2 seats goes like this, that in 2016, the Republicans violated the then existing norm of at the very least giving some sort of hearing to a Supreme Court nominee, which they didn't do with Merrick Garland. And then they established a new norm, which is that we don't do that in a presidential election year. Having established a new norm in 2020, they violated the new norm. And so you have 2 different norm violations, albeit of 2 different norms. But so that I think is the logic for those progressives who say the 2 seats were stolen. Maybe the best way to think of it is that this is a kind of metaphor for saying that 2 seats were filled with Republican appointees in violation of then existing political norms, at least as the Democrats perceived those norms to have been. And in the second case, as the Republicans said the norms were.
I mean, it's kind of an interesting question if you're thinking as a progressive, if you do believe that a seat was stolen, and I think that's fair terminology, though that's not what I'd like to spend this session talking about. Like, what is the adequate remedy? If it's really a stolen seat, just doing packing the court by 1 seat doesn't feel quite like you're restoring things to the status quo, right? Because now you've just neutralized the seat, but you haven't gained the seat that you had before. So if it's 1 stolen seat, from a progressive point of view, packing the court by 2 seats might feel like the only thing that's somehow adequate to remedy the injury.
And let's make that, just to expand the question, Josh earlier had asked sort of, short of the nuclear option, what can we do to maybe mollify progressives? I mean, the real problem is just that the temperature keeps rising on this. I guess the closest that we've come to the current situation is the politically motivated decrease in seats and then increase in seats at the time of the Civil War. And needless to say, temperatures were very raised then, and perhaps they're more raised now than at any time since the Civil War. But what could we do to lower the temperature short of court packing? And maybe that's a reform to the court, maybe it's something else political to lower the temperature. You could all address that.
One thing that I'd suggest is using better, more accurate language. The word stolen right off the bat, that has 5 layers of spin on top of it that necessarily says all kinds of things, many of which are simply not true. So I think using language which at least is more that fits a situation better, and so that the nature of a problem and the consideration of possible solutions or responses is more legitimate. I mean, again, and I was Senator Hatch's chief counsel in 2017, and I know the reasons that Republicans gave for not advancing Merrick Garland, and it was not simply because it was a presidential election year. They never said that was the norm. There were specific factual circumstances that existed that defined why that presidential election year meant that the process should be deferred. But right off the bat, depending on how you view those things, what the norm is completely changes. So I think using language that is better suited for what the actual conflict or controversy is. Look, the Senate has handled Supreme Court nominations at least a dozen different ways in our history. Some of which people like, some of which people don't. When you don't get what you want, unless it is manifestly illegal or unconstitutional, one person's norm is another's annoyance. I mean, that kind of thing happens all the time. So anyway, I just think, and in my experience in the Senate, using language which doesn't try to set up kind of a false perception it helps both sides to perhaps meet a little bit more often and to have a little bit more possibility of understanding the other's point of view and maybe a little bit of common ground.
Yeah, let me just come back with 2 short things. I'm sure Ilya has a lot to say about this, but one, the 18-year term thing is the one that a lot of people are centering on, and so I just want to address it briefly. I think it's a wonderful idea. Do I think it is free of problems? No. And do I think it's going to lower the temperature? Probably not. I just don't see, so the 18-year term idea, how does that gets rid of people strategically retiring? It's a good administrative and performance reform. But the issue has been about whether you can confirm a Supreme Court justice when the Senate and president are of a different party. And there's nothing about that proposal that deals with that. There's nothing about that proposal for progressives who are interested in packing the court that will somehow remedy the injury that we feel that has occurred. And there are some real kind of problems with it. One, does it require a constitutional amendment? That's a big argument that's happening. And then regardless, even if you view that you can do it with statute, what are you going to do with the current justices who have life tenure? When you start cracking the numbers, you start seeing an accordion court that goes up in numbers and then lower in numbers. You might have an 18-year justice who's appointed by Biden, say in his 3rd year, and then retires before Amy Coney Barrett does. So those are some things that just have to be worked out. How could the temperature be lowered? Well, in my opinion, the court could back down when it's going up against progressive priorities. And this is where I think I'm different perhaps than maybe other members of the panel, as I can see from Tom's reaction. Right? Which is, sorry, Tom, that's perfect.
In other words, you can lower the temperature by letting me win more.
Yeah, right. Well, that's
Okay.
kind of my reaction to your statement as well, to be fair, which is that, that's the way the court has worked historically. It's been, as one person put in the comments, self-regulating, right? When it comes up against unified opposition from the political branches, which is very, very rare, by the way, and we don't have it today, by the way. That's what you would need to get something like a court packing statute passed, right? You would need to have enough votes to abolish the filibuster. The court has generally backed down. And that is the real story of the New Deal and the failure of the court packing story, the switch in time that saved 9. It goes back to Marshall, who basically dealt with Jefferson, saved the judiciary by backing down against Jefferson's onslaught, more or less. And we can go on and on with more examples. And I hear from conservatives today, you know, this is judicial cowardice, this is judicial abdication, right? But it's partly what happened with the Warren Court, at least in its early manifestations too, which also came up against attacks like impeach Earl Warren, right? Many threats of jurisdiction stripping, as we all remember, over school prayer or school busing, right? The death penalty, basically, the justices back down when they realize that they don't have support. And so to me, this is part and parcel of American history, is the court self-regulating and backing down in order to save itself from more egregious political attacks.
So you see that as a good thing. We did have one of the audience members asked about the likelihood that Roberts, Kavanaugh, and Gorsuch would basically vote in a more liberal manner because of the threat. You know, we could debate which members of the court it would be, but you know, I think most people think of that as sort of a loss of judicial independence. But if I understand you correctly, Josh, you're saying that's part of the political process. It's not a bad thing.
Absolutely, right? Marbury v. Madison, what happens in that case is that Jefferson, there are I didn't go into this in my talk, but circuit courts are created, they're packed. If there's this is a real precedent for court packing on the lower level. And all these life tenure justices, Jefferson turns them out. He just basically kicks them out of the judiciary. And we read Marbury v. Madison, which is about a justice of the peace. The guy never becomes a justice of the peace because the court says we have no jurisdiction. And then in another decision, which we don't really read, Stewart v. Laird, the court says, we can't do anything about this. We can't do anything about these life tenure justices suddenly being robbed, right? And that's just one of many examples. And it doesn't mean that the court should always, whenever something they want to do is has political opposition, they should always back down. It's only at these very rare, 5 times in our history kind of fever pitch that the court has to figure out when to back down.
Ilya, did you want to say something?
Yeah, just a brief comment on this. I think Josh is right that the court has a number of times historically backed down when they faced overwhelming opposition from the political branches and from public opinion. That's a very different thing than what is going on now, where the court deals with a number of issues that are highly controversial, but which both the public and Congress tend to be closely divided on: abortion, affirmative action, gun rights, immigration issues, a number of other things. And that's not like FDR's overwhelming New Deal majorities or the overwhelming majorities that the Jeffersonians commanded in the early 1800s. So to say that the court should back down on these issues where either progressives are in a slight minority or at most are in a slight majority on most of these questions, perhaps campaign finance being somewhat an exception, that's very different from what happened in these other cases. Maybe the court should do that on other grounds, or maybe you just want to argue, well, the conservative side of these decisions is just wrong. On a few of these cases, particularly immigration ones, I actually agree with you. I think the conservatives were wrong on a lot of what they did, but that's still a different situation than what occurred in the 30s or in the confrontation between Jefferson and the court and so on. I don't have a brilliant alternative strategy for lowering the temperature. I think judicial term limits can lower it a little bit, but not enormously. I might be open to expanding the court if it was part of a constitutional amendment, which fixed the court permanently at a new number. So one can imagine expanding it to 11 or 15, and then having new justices gradually be appointed over a period of years, but then make that new cap permanent. But the fact that I might accept it doesn't get you very far, because you still need the broad supermajority to get the constitutional amendment passed. And sadly, what I've found over the years is my political influence is extremely limited and certainly not great enough to get a constitutional amendment passed.
Well, speaking of constitutional amendments, another audience member points out that there have been in the last few years constitutional amendments proposed, one to fix the number at 9, and one to say that you can't increase it. but you could decrease it. The one that would fix it at 9, I know, is sponsored by, I think, about 60 House members and 15 people in the Senate. It even has some bipartisan support. Putting aside whether, we'll ever have the 2/3 to pass something like that. One, is it a good idea to have a constitutional amendment? And two, for which of the proposals would it be necessary, where literally you'd be violating the Constitution if you tried to do it legislatively?
I'd suggest that, here, one initial consideration is what the Constitution is properly used for. The number of justices or judges on any particular court is a legislative matter left up to Congress. I don't think that making that public policy decision in the Constitution is probably appropriate. And I'm not sure what is magic about 9 really to begin with, because that's what you'd be doing. You'd have to have a compelling case, not only that policy decisions should be made through the Constitution, but also that number is so important that it should be constitutionalized. I personally think that's, I get the motivation behind it, but I think that's a tough case to make in terms of what a constitution versus legislation should properly be used for.
So I think it would be good to have a constitutional amendment to fix the size of the court, whether at 9 or some other reasonable number like 11 or 15. I'm sort of indifferent on the number, though 9 is kind of cool because it's the same as the 9 ring wraiths from the Lord of the Rings. But it's not that 9 or 15 or some other number is sacred or ideal. It's that it's good to prevent court packing, which has been very damaging in other countries where it's been tried, and where I think here in the US, the genie is sort of out of the bottle, so we can't rely on it, I think, being indefinitely prevented by political norms. In order to achieve that, as I mentioned before, I'm open to compromises on what the numbers should be. And we can make it 11 or 15 or something. I wouldn't want to make it too large, wouldn't want to make the court like a legislature, but a number somewhere in the teens, I think, would be fine. And I think taking court packing out of the armory of political weapons is something that's desirable, and is the kind of structural safeguard that a constitution can reasonably include.
Josh, your thoughts?
Yeah, I agree with Ilya. I think it's mostly important to stop tampering. I think many other countries do have the number fixed in their constitutions. The only thing I want to push, the thing that's interesting to think about is when court packing abroad has actually worked. So Germany after World War II, and the Soviet Union. There are cases where court packing has worked because they think the current political regime is so corrupt or so problematic that you actually do need to establish something like a whole new judiciary. And, in the United States, I have real issues with the Johnson case, but you basically don't have the 14th Amendment very likely if the Republicans had not packed the court, because we know, and if they hadn't stripped jurisdiction, right, in the McCardle case, because what the court was likely rearing up to do was to strike down the legislation that set up the framework for ratifying the 14th Amendment. So I don't like court packing. I think it's really dangerous, but I think it may not be a risk worth incurring. But there are some moments where it might actually be important, right? And I didn't have enough time, but history doesn't bind us, and we always have to look at the present. So anyway, that's just my guilty liberal part.
We only have a couple of minutes left, so I want to sort of get back to the commission. Tom seems to think, it's pretty much the commission is just a cover for what will be court packing. And then Ilya said something very different, that he thought not a lot of radical proposals were going to come out of it. So I'm going to let Josh break the tie here. What should we expect from the commission?
Yeah, being friends with and very close with some of the fire eaters, some of the court packers, I can tell you that this thing doesn't come anywhere near that. So for some of the reasons Ilya said, maybe Carolyn Fredrickson might count as someone who possibly could be open to court packing, I can imagine. But Bob Bauer has written against court packing. Jack Goldsmith, I don't see as a friend of court packing. And, the average liberal professor, right, is someone who, before all of this, was really against court packing, after the first appointment was really against court packing, and now is like internally torn. That every kind of norm that they've grown up with tells them that they hate the idea, and yet they're really angry about it. And so the depiction of Democrats, or the average liberal even, as being the average kind of political liberal as well as law professor, just being like so gung-ho, ready to pack the court, I just don't think is right. I think there's just people who are really conflicted about it internally, including myself.
Well, we got a lot of questions today through my email and through the Zoom functions. Fortunately, I apologize to everyone that I was only able to get to a few of them, but I want to thank the panelists for a great panel. I think it was a great debate. I think the audience definitely learned something. I learned something. And so again, I want to thank you all. We do these panels frequently. Hopefully we can have you all back for related issues. And to the audience, I would say tune in again soon for another interesting panel. Thanks
Thank you
to
so
all.
much.
Thanks,
Thank
Kurt.
you.